You. Okay, great. Welcome everybody. It's nice to see the folks that I've worked with and that I know. We're going to be talking. So let me start over. I'm Anna Walsh. I'm with the Appellate Court's ADR division, and my colleague Crystal Curry is here with me today as well.
Good afternoon.
I'm the director of the division. Most of you know me, and you know that I was a practicing attorney before I went to work for the courts in different mediation programs, and my background was family law. Crystal, do you want to just go ahead and say a little bit about your background?
Sure. Hi, Crystal Curry. I'm one of the staff attorneys here with the Appellate Court. Prior to joining the court, I was in private practice where I litigated civil matters. I did a lot of domestic as well. And I also mediated for the DC Superior Court, the Montgomery County Circuit Court, and also privately before coming to the Appellate Court as one of the attorney mediators. So, hello, everyone.
Okay, I am going to go ahead and share my screen, hopefully. Okay, can everybody see that? Yes? Okay.
Yes.
Okay, great. Hang on just a second. Here's mine that I'm going to look at. Okay, so I just wanted to start out today with a plea. If anyone is interested in volunteering with us, we have a significant number of cases at the appellate court where one or both parties are self-represented. In our program, we generally do not mediate cases where we have a self-represented litigant. They are dealing with important appellate rights. We cannot advise them. We don't want them giving up any rights in an agreement if it's not in their best interests or if it's not in their considered interests. So we are really looking for a group of folks who might be willing to do some pro bono work with us. And that would look like volunteering to represent a pro se party just in mediation. We would not, if the mediation fails, we would not be looking for people who would carry on through the rest of the appeal. This is a new idea, so we would like to gather a group together to talk about it, to kind of craft what it would look like. It would be family law cases with folks who would probably qualify, at the circuit court level or even up here with fee waivers. So you wouldn't be giving your time away to folks who could afford to hire you. I know that, can be a sensitive subject, so we wouldn't ask you to do that. But, of the family law appeals that get filed up here, around 40% of those cases have one or more self-represented folks, so we can't mediate them. When we do mediate family cases, we have a very high settlement rate. So I think that we could make a great impact on the appellate court if we were able to get some of you guys roped into some pro bono work. So I just wanted to start out with that. The basic structure of our program is we have a staff of 4 full-time attorney mediators, including myself, and all of us have practicing attorney backgrounds. Our roster is comprised of retired judges and family magistrates who have all been trained in mediation. They've all gotten the 40-hour training. They all take 4 hours of advanced mediation training every year. We keep them up to date. Magistrate Fernari, whom a lot of you might know from Baltimore City, has joined our roster in the past year, and we have her working on family cases with us. She's doing great. So what we do is we have a co-mediation model. So whichever one of the staff attorneys screens the case will then pair up with a judge or magistrate mediator to co-mediate the case. The cases that come to us are all of the civil appeals. We don't handle any of the criminal appeals. So our office screens the approximately 1,200 civil appeals that are filed each year. for appropriateness for mediation. The services that we offer are mediation, which we just talked about a little bit. And generally, we set those in for 4 hours at a time because people are, they want to get it done. And they may have gone to mediation before. This is, might be their last chance. If they don't resolve the case with us, they're looking at a longer appellate process, possibly going back to the circuit court based on what the issues are. So they're looking at prolonging the road ahead of them if they don't settle here. So we do set them in for 4 hours, and we will do follow-up sessions if everybody wants one and we think it would be beneficial. We can also set your case in for a pre-hearing conference, which kind of looks like a settlement conference. And again, it's co-facilitated by the screening attorney and a judge mediator. And they're a little bit more straightforward. So the mediation that we do up here is generally facilitative mediation. The judges are not here to tell our folks, to tell the participants what to do, but they do bring a lot of gravitas and judicial experience to the table. So they're very strong reality checkers. In the pre-hearing conference, they can be even stronger reality checkers. So if you have an appeal that you think is kind of on the fence, but you would like a negotiation opportunity, or maybe you have a client who needs a bit of firm, logical pushback, a pre-hearing conference might be a good option for you to resolve the appeal. And then we also do pre-mediation facilitations, which is really if you and counsel have been speaking already after the trial or after the circuit court matter, and you think that, you're close, but you need some help, but you don't need a formal 4-hour mediation or pre-hearing conference, you can ask us to convey offers back and forth. We might be calling you to do that and kind of encouraging you to do it if we think that the case ought to be resolved. Part of our job up here in this office is to help with managing the docket of these appeals that go through. And if you have a case that ought to resolve, and there are attorneys who are like, Anna, this case really should resolve. We really shouldn't be up here. A pre-mediation facilitation can be an option for that. And all of these processes are confidential. We don't share anything with the court unless there's been an agreement reached that needs a remand or a voluntary dismissal. Any questions about any of that? And Crystal, do you want to add anything? Okay.
Nothing to add.
Okay. And guys, just speak up. I can't see everybody. So unmute if you have a question. Just go ahead and chime in.
Thank you. So we spend a lot of our time screening cases for mediation. The question is it a good case for appellate mediation? That doesn't mean that the case has to settle. It means that the parties are willing to have an open dialogue. And I emphasize the parties because often counsel will say, this is a great case for mediation. And when I ask, what do your clients think or what does your client think? They're like, well, let me check with them. We have to have the parties buy in order for them to come to the table. When we started screening the case, we're looking at the posture of the case. Where is it? Is this an interlocutory appeal? Was this a motion for summary judgment? Was this based upon a motion to dismiss? We're trying to gauge where the parties might be and also what the other side might be willing to do regarding coming to the mediation table. We're going to talk to you about the legal issues in the matter, like why are you here? And also just if you've had any prior settlement discussions, whether formally or informally. So when we call, we'll ask questions about, the status of the parties. Is it an individual, corporation? And these, I guess you all mostly have like just parenting issues. Is it a third party involved? Is there a third party custody matter involved in this? Who needs to come to the table? What are the power dynamics regarding the relationship? The ages of the parties, their relationship, their past history. We also, in our domestic cases, we screen each case. We in addition to talking to the attorneys about whether mediation is appropriate, we also have separate conversations with your clients to really look at and screen, their communication styles. And we gauge from that how we structure the mediation, if mediation is appropriate. We're looking to see, is there a past history of domestic violence or something of that sort. Um, just because there's a past history of domestic violence or maybe a protective order, that does not stop us from mediating a case, but we need to talk to the parents, the parties involved, to really identify whether it's appropriate, and also the attorneys to see whether it's appropriate. Um, we're looking to hear about the interests and the needs and the goals. Oftentimes, a lawyer might say, this is a great case. I'm not going to get a published opinion out of this. I'm looking forward to oral argument. But the real question is, what does your client need? Does your client need an apology? Does your client just need to be heard? Or what are their main interests and goals? If they just want this over and done with because they're tired of dealing with this matter or being in court, then that's what they want. While this might be a great case for counsel to make a name for him or herself or they self, it's like you have to think about the client. It's all about the client's choice regarding mediation. Are the parties willing to talk? We typically start off in an open joint session, and we oftentimes will break apart into separate rooms, but are they willing to have a conversation with the mediators about their options? Are they open? Are they willing to compromise? Sometimes parties like what the judge did in the circuit court, and bringing them to mediation sometimes is not helpful if we have to twist their arms so they don't want to move. If they don't want to move off the alimony or the marital property that was awarded, it's very challenging to have a good mediation. And we also, during the screening process, we're going to look at what supports and accommodations do your clients need, do the attorneys need. We do have interpreters available to assist. Regarding supports, is there a person who needs to come to the table with the party? Should they be in the private caucus room waiting for the party? And I know some great mediations we've actually had the step parent for one of the parties to be at the table to help, because they were to drop off and pick up person. So it's very helpful to have everyone who could be helpful there, whether it's in a private room or actually at the mediation table. So when we call the attorneys, what we're looking to do is to discuss the legal issues. We don't limit our mediations to the legal issue on appeal, but it's helpful to know why you're at the appellate court, and also if it's appropriate for you to be at our court. Sometimes it's too early. Sometimes there's still matters pending in the circuit court, so the timing is not quite right or the issue might not be appropriate. And so we'll talk to you. We'll also ask questions about the attorneys' working relationships. How do you all get along professionally? At times, we're mediating the lawyers. As you're aware, if you've been in, for example, a custody matter or a divorce matter, you might have been in that case for many years. If you're a trial counsel, now you're on appeal, so maybe there's a 5-year period where you've actually lived with this family. So we want to know, your involvement. Has the other attorney adopted their client's personality? Have they made themselves part of the family? So now we're mediating, all of these issues. So that's very helpful for us to know how the attorneys get along. Are they respectful of each other? Sometimes you might have a newer attorney that might not garner a lot of respect from a more, seasoned attorney. So we're looking for that. We're looking at practical considerations. For example, if there's an alimony award on the table, the question is, would the person prefer a lump sum sooner than later instead of waiting for a payout over 15 years or so? So we do look at how matters can be collected. In our civil cases, we might look at, is a business going to stay in business, or will it be viable? Does it have assets if you're looking to collect money? So we're just having those very practical conversations. We're looking at the lawyer client dynamic. Sometimes counsel will be very candid with us and say, I've been counsel for this person for 20 plus years. They trust me. If I bring them to the table, they'll trust my recommendations. Just let us come to the table. And sometimes they'll say, as Anna mentioned, we need a judge to really strong arm my client, or a magistrate mediator strong arm my client, because they're just not getting it. This appeal is not very strong. So again, we're assessing that. And we're also trying to figure out if the parties are represented. Sometimes we'll refer a case out to the University of Baltimore School of Law to have their student attorneys assist in representing the parties in mediation. Or if one of you would be open to doing so, that'd be very helpful. But we try to make certain that everyone coming to the table has representation, because although we have legal backgrounds, we cannot give legal advice. And so we're looking for an outside counsel to really guide them as to what's helpful, what's not. Sometimes we've done pre-mediation facilitations where we'll have a person who's not represented negotiating with another side that is. And in that situation, we're looking to the unrepresented person to at least get guidance and counsel from an attorney to review the settlement agreement if an agreement is reached. So it's very, very helpful in our mediations.
Yeah,
and what we're looking for is the attorneys to really tell us, is this a good fit? You know, why is your case a good fit for appellate mediation? We often hear things like, oh, I believe in mediation. I'm a mediator myself. But the question is, can you share with us options that your client might be willing to agree to or open to discussing?
Yeah. And Crystal, if I can just add, in terms of
Next
the
slide.
UB, hang on just a second.
Before
Oh, she can't hear
the next
me.
slide. Yeah, it's okay. So before a case is scheduled for mediation, if we've gone through the screening process and everyone has, Anna, did you want to talk about the MASIC screening more? Okay, sure.
Yeah. Crystal, can you hear me? I don't think Crystal can hear me for some reason.
We can't hear you.
You can't hear me. Can everybody else hear me?
Yes.
Okay.
Yes.
I'm going to back up
And
just
anyone
a second.
hear Anna?
So hang on, I'm going to chat to Crystal just for a second.
Anna, I couldn't hear you.
Yeah. Hang on.
Okay. 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 Great.
So just backtracking just for a second, I just want to touch on that strong arm comment. Our judges do not strong arm anybody into an agreement, but I think what Crystal meant to say really was that they can, again, be quite frank with people. Especially if counsel wants to talk a little bit around, an evaluation of the strengths and weaknesses of the issues on appeal. In caucus, the judges may do that sometimes, which actually can be very helpful in moving people along. And the University of Baltimore Family Mediation Clinic provides student attorneys to represent some of our pro se parties. But as you can imagine, the law school clinic is limited in the number of cases they can help us with. So that's why we are asking for additional assistance from private attorneys. And they can only handle cases when school is in session. So all summer long, we have nobody to help out. In our child access cases, as Crystal was saying, we do screen those cases when they involve parents, people who have been involved in an intimate partner relationship. We do use the MASIC-S, which Baltimore and Frederick counties right now are also using. We interview each party separately, and normally the attorney does not attend the, hang on a second. Crystal, yes. Hang on a second. Usually the lawyers do not attend this screening, and it generally is, we do the IPV questions and the MASIC, but we also do chat with the parties about what their goals are for mediation and make sure they understand what our process is going to look like. And they can share with us ahead of time what they would like to see happen. And as the mediator, it's very, very helpful to talk to the party. It's a confidential conversation. I don't share it. We don't share it with, anybody else, only our co-mediators, so that the co-mediators can prepare for the session. And so it's also time efficient so that we don't have to start off the session or the caucus sessions with the parties, spilling their whole backstory. They've already had an opportunity to do that. So it's very, very helpful. In terms of setting up your client to be successful in our ADR sessions, we do ask you to fill out a confidential information statement. It's like a pre-mediation statement. You can do your own or you can use our form because there are certain things that we're looking for. We really want to know that the attorney understands the standard of review. There are attorneys who come up to us who don't really understand the standard of review for their case. So it's really important that you understand it and that you can communicate it to your client so that they understand what they're up against when they come up to the appellate court. Sometimes, parties' goals don't necessarily change from the time of trial up to here, but they might have a different approach to achieving those goals, or maybe even letting some of them go, especially if they're the appellant. And so they were the loser at the court below. So they might have a more realistic approach to settlement when they get up to us. So it's very important to us that you chat with your client about those goals before the mediation and work with your client to come up with some reasonable settlement options so that they have done homework before they walk into the mediation session. We also think that you should have a conversation with your client about what are the costs of settlement at the appellate court versus proceeding with the appeal. And that's time and money. Be realistic about what remedies the court can actually provide to your client. And do a cost benefit analysis with them of what their resources and life will look like if they settle at this point versus what it might look like if they continue on with the appeal. I had one mediation where money, the issue was money, but money wasn't really the issue. The appellant didn't like the appellee, was willing to continue inflicting the pain of litigation on the appellee. We did a mediation. It didn't settle in the session, but 2 hours later, I got a call from counsel saying that they were settling because the appellant went home and talked to, the real power in the family, his wife. And this was a different civil case. This wasn't a family law case. And she did not want to live with this case for another year or two. She had it. And so he did make the assessment that overall, in the grand scheme of his life, it made sense to settle than to continue on with the appeal. During the session, just like in all mediations, try to model good communication style, good behavior. If you're getting upset, or angry or positional, that's not necessarily going to help your client. And you want to help them manage their emotions, maybe go in and have a word that they can use if they need to take a break or to talk to you privately. Obviously, we're always going to offer opportunities for counsel and client to speak privately. And we do use a lot of caucusing. We really try to keep, especially in family cases, people at the table in joint session for as long as possible. But we also do respect, when parties want to caucus and just meet with the mediators separately rather than in joint session. And of course, as always in mediation, we want to stay forward focused. This is not an opportunity for everyone to look backwards and try at this point to correct, what they think went wrong at the trial. This is about looking forward and coming up with a resolution that's going to be sustainable into the future. If you settle your case, we look to the counsel to write any agreement that might be necessary, to draft a consent order and to draft a remand. We will help with the drafting of the remand if the case needs to go back to circuit court, for example, to put a consent order on the record. And we almost, we're always looking for you to file the voluntary dismissal. So we can't do those things for you. We can assist you with the process, but we can't do it for you. And we do look for attorneys to do their jobs in that respect. And also, if you want to, extend the time for ADR, because the court does like us to resolve these cases within 4 to 6 months of the order being entered. If you want to extend that time period, we would be looking to counsel to file a joint motion for that. And normally the appeal is stayed pending the outcome of mediation. There are cases that go forward concurrently with mediation. So the timeline is still moving forward, but most often the appeal is stayed. If there's no settlement, there's going to be an order for the appeal to proceed entered. And that is going to start your timeline for ordering transcripts and transmitting the record from the circuit court to the appellate court. Once the appellate court receives the record, then they will issue a briefing schedule. Crystal, did you want to add anything to that?
No, it's just really helpful. Sometimes we tell parties at the table, you can know your outcome today, or you can wait another year to get an outcome from the court. And we often reiterate that time is money. And do you want to keep living in this? And it kind of helps them to really reposition themselves if they have taken a position on a particular issue, or just to really think about the benefits of settling them.
Yeah, and I think it's also good to keep in mind, if you have a case that you think ought to settle, but there is some sort of barrier that your client is throwing up, and especially if both counsel think that the case should settle, but the clients, one or both clients are digging in their heels, remind them that the rules do allow the panel to suggest mediation. So you could get to oral argument. You've done all that work. Your clients have paid all that money. You get to oral argument and the panel goes, counsel, have you thought about mediation in this case? And if the panel is saying that to you, normally lawyers do take that hint and they contact us. And the panel will delay issuing an opinion until after the parties have had a chance to mediate the case. So again, if you have a case that you think ought to settle, you can tell your client that there is a possibility that the panel is still going to send them to mediation. Everybody has to agree to mediation, to consent to it after oral argument, if that has already taken place. But it is still something, a reason to get it settled now rather than risking that.
So many people ask, why mediate at the appellate level? A lot of times you might have had some type of mediation or a settlement conference at the circuit court, or you might even try to talk after the court's opinion was issued in this case. But why mediate at the appellate level? One, is cheaper. Our services are free of charge. The parties have to pay for their lawyers coming to the table, but you don't have to pay the mediators. Many of our judge mediators and our magistrate mediator do mediate privately, and they're very expensive. So you can get the good quality mediators for free of charge by coming through our program. Also, as we said, it's much faster. Again, we reiterate today versus next year regarding getting a resolution and an outcome. Oftentimes getting some type of money in hand, money in a bank, you can accrue interest on it potentially, instead of waiting a year for the court to issue its opinion, which might not be in your client's favor. The parties control the result. Sometimes we'll have matters where maybe child access was at issue, and neither parent likes the decision of the circuit court. Here, you're able to kind of morph the schedule the way you want to. Or if there's something else, again, I mentioned alimony before in another example, even marital property, you can kind of morph it and control the outcome of the case instead of waiting for the three-judge panel to make their determination. You reduce the risk. If you're practicing in this area and this case that you have moves forward, how will that impact future cases that come down the line? Is this particular case going to set precedent for other cases that follow? Is this the best case? So you often reduce the risk of the impact it can have on you professionally, but also on the parties. The risk, how long will the parties have to sit in limbo waiting for a determination? In our estate matters, we might have like multiple generations coming to our table. And as long as they're in litigation, they're not talking to each other, they're not, hanging out with each other. But once the mediation is done and they can close this litigation door, they can go back to being a cohesive family again. So that's also helpful. And that goes into managing the trauma. I mean, as you're aware, a lot of information comes out during litigation. We've reviewed transcripts and we've heard various things from people sharing information about odors and intimate details regarding their marital relations and recreational habits and hobbies. Does your client really want to continue making that information public, or do they want to have like a private conversation and discuss those issues with just at the mediation table? And also, it just kind of helps them to just move forward. For many people, going through court is such a traumatizing event. We do it often. We live in courts. That's what we do as our jobs. But for the actual client, it's very different. It's their lives, it's their lives. They're living in this, and it's not a very happy time for most of the people that we meet. And so the question is, how do we minimize that stress, that financial strain, or just the uneasiness of actually being in this litigation setting? And so we think that mediation definitely helps to manage the trauma that people experience, and also just adds more like a human nature of letting them have their voice heard at the table versus having them just answer the questions that are asked. They get an opportunity to just tell their story to a third party.
Yeah, and I just, in terms of the trauma, I would just want to add that we're talking about the trauma for the children involved in these cases as well. And conflict between the parents is a strong indicator of the child struggling even as adults. And so it's important for parents to remember that their children are caught up in this conflict also, no matter how well they think that they are shielding their children from it. So the sooner the conflict can come to an end and the family can move on, no matter what the decision is, at least the family can move on, the better.
So appellate mediation just offers the unique opportunities for people to have the conversation that they're struggling to have. You can directly talk to the other parent, to the other party about what's going on, and just have a very calm discussion that maybe that they're trying to have on their own, but every time it happens, maybe something blows up. Oftentimes, the parties want to feel heard by a judge or a magistrate. They really want the judge to hear their story or magistrate to hear their story. And so mediation offers that opportunity. Some of the cases that come before us might be here procedurally as a result of a motion for summary judgment or motion to dismiss. So your client has never had the opportunity to take the stand, to tell what happened or why what happened to them is wrong, or even just how they feel. Because again, your line of questioning will be based upon something maybe more rigid and strategic than like, my feelings were hurt. Will that come out in direct testimony? So it's a great opportunity for people just to get it off their chest. And once they can just share it with someone who will listen, particularly a judge or a magistrate, they feel better. And once they feel better, they can kind of move forward to having a discussion to trying to resolve the issues at hand. It lets lawyers talk to each other. Oftentimes when we're screening cases, when we call an attorney, we say, have you had a conversation? Well, no, I don't think that they'll want mediation, or no, I haven't talked. I don't want to appear like that I think that my issue is weak. And so it allows the lawyers to be comfortable and have that safe space to just have a discussion about, what about this? What about that? Let's just throw some ideas out there without them feeling like it's going to have a negative impact on their appeal, or any other pending motions. And I'll add pending motions because what we do encourage the parties to do when it comes to mediation, if they're pending matters in the circuit court, we invite them to reach a global resolution to resolve everything. It's not required, but it's helpful to get everything taken care of so your issues on appeal do not limit the scope of what you can discuss at our mediation table. And also, it helps the parties work towards their true goals and their interests, whether it's setting boundaries. You know, a court order typically will not set boundaries for, you know, when a person can hug another person. I don't know. We can just kind of get into the minute details at mediation, but maybe there's an overbearing stepdad or stepmom, and you can just kind of sit there and really iron out the finite details. We'll take our time with it, whereas maybe a circuit court judge that has like a docket to keep moving forward might not be able to put that much time and attention into those particular details. Or maybe your client is not as creative on the witness stand as they might be at the mediation table. So it definitely allows people to really focus on what their true goals are and their true interests. Sometimes an apology is what someone wants. But I don't see apologies in court orders that come up here. So we can really focus on what is it that you're looking for and really ask those real questions about what are your needs, your goals, and your interests, and try to work towards helping the parties resolve the case.
Yeah. And I think it's really important to point out that a lot of what we have talked about is what every mediation program talks about, giving the opportunity for the parties to be heard and generating options, mediators establishing rapport with the parties and with the lawyers. Really, what makes us stand apart is that when you get to this level and use our program, you have an opportunity to have a conversation with an experienced judge or magistrate. And I really can't stress enough how beneficial that can be to the process. Again, not because they are making decisions about what your clients should do or about how you should handle your case, but they bring a lot of judicial experience that allows them to have meaningful conversations with counsel and with parties to talk about, the law around the issue, to talk about what the appellate court can actually do for your client, because clients oftentimes don't understand that taking an appeal, even if they win the appeal, doesn't mean that they are necessarily going to get another bite at the apple. What the appellate court can do for them is really very limited. And for a party to have the opportunity to sit at a table, and we do mediations in person or online, but many of the family law mediations are in person. For them to be able to sit at the table with a judge, they've got their lawyer there, they've got a judge there that they can sit and talk to, and the judge is tuning into them and listening to them, and not all the rest of the chatter that is happening in a court case, is very helpful. And as I said, we have a very high settlement rate in our family cases. And I think that, this is one of the reasons. And to be able to have one of our judges co-mediate a case for free is a pretty big deal in the mediation community. I mean, you guys know how much you pay judge mediators who are in private practice to mediate in your family law cases. So this is a bargain. And it's a good process to boot. So I think it's really important to keep that in mind if you bring a case up to the appellate court. Crystal, you want to go ahead and wrap up?
Sure. So just a few takeaways. We're here. So if you wouldn't know that we existed, we exist. And if you don't receive a call from us, which would be rare, about a case, feel free to reach out to our office to say, I think I have a case that's good for mediation, and we definitely will go through and screen it. We do have limited resources, as Anna mentioned. We're screening 1,200 cases. We have 4 staff attorney mediators. So we want you to really help us help you. Help let us know why your case is one of the few that we should accept, and help us to figure out what resources would be most appropriate. So definitely have those confidential, candid conversations with us when we give you a call to screen the case. We'll discuss legal issues and assessment of the risk, but we definitely want to focus on your client's goals. So definitely we want your clients to be involved in the full process. We screen the cases with the lawyers only, but we want you to have your clients your client's buy-in. Let us know what your client is really looking for. And even during the mediation, we're looking to hear directly from your clients as well. So make certain that you bring them to the table very prepared. They should be involved in the preparation of the confidential information statement. They should be involved at the table, and make certain that they're really, really clear on what they want, but also have flexibility with that.
Yeah.
Does anyone have any questions for us?
So I just wanted to confirm, so we could proactively contact your office if we have an appellate matter that we think is appropriate for mediation. We don't have to sit back and wait to hear from you guys.
Correct.
Yes.
Yeah. No, the process is we do screen every case. So if, we look at the civil information report that you file with the appellate court, which gives us some information, but usually not enough. So we do reach out and speak to each attorney in the case. But if you haven't heard from us for some reason, please do call and reach out. And like Crystal said, we will screen the case or we'll explain why the case might have moved forward without ADR.
And we're reaching out.
Go ahead.
You can also, our office can remain, we can assist as long as the appellate court hasn't issued a written opinion. So sometimes counsel will say, this case isn't good for mediation, but after the matter has been briefed and they've seen the other side's arguments or they've reviewed their own, they might be more inclined to want to come back to mediation. And the appellate court is very, responsive. If we prepare an order for the chief judge to sign that, stays the matter pending mediation, the court will do that before and potentially after oral argument. So definitely reach out to us if you think there's a chance of having a discussion even after the matter has proceeded through the appellate process.
Yeah. And, again, we're looking for volunteers. We're looking to have the conversation around what the volunteers would want it to look like. If they do help us out, we do not want to lock you into doing 20 hours of pro bono time. That's not what our intention is. And we realize that would not be reasonable for you. But if you are interested and you wanted to have, to help us craft what it could look like, please email me or call me, reach out. And, as soon as I get a group of stakeholders together, we can have that conversation and move forward with that.
Awesome.
Okay. Any other questions or comments, Craig?
I was just going to open the floor if anyone wanted to ask a question. And if not, thank you, Anna. Thank you, Crystal, very much for this information. That was certainly helpful. I know a lot of us family law practitioners aren't in the appellate setting very often, so it can be somewhat foreign to us. So the more information we have, the better.
Mm-hmm. Sure. Okay, if there's nothing else, although Jeff, you did turn on your camera again. I guess you're finished eating. Don't know if that was because you wanted to say anything.
Yeah, actually, are the mediations necessarily in person, or is there can you handle remote?
We can. Yeah, I mean, we can do them over Zoom also. I personally like to do them in person, but what we're going to be doing is talking to the lawyers. We want to know what their clients want to do in terms of scheduling all of you folks, along with trying to get, the judge who's well suited to the case, their availability. So if the only way we can manage it in a timely fashion is to do it over Zoom, we'll do that. In person, yeah, generally we're dragging you to one of the facilities in Annapolis. But if there are facilities available in the county where you are, and we have a judge who's willing to go there, we will try to, we might be able to accommodate that as well. Okay. If there's nothing else, I'm going to go ahead and sign off. It was nice to see you, and always feel free to contact us with questions. I'm just checking the chat. Thank you, thank you. Thank you guys for attending, and I'll see you.
All right, take
All right,
care. Have a good
everyone.
day.
Good night, everybody.
Thank
Bye-bye.
you.